My name is Ryan Chandrapala. I'm from Armchair Criminal. I welcome you all to this part of the program. This is the second part of a four-part series in the first section of common law exceptions to the hearsay rule. In this part of the program, we will consider three topics. Rule 1, public information or public document. Rule number 2, reputation, that is good or bad character. Rule number 3, reputation or family tradition. Let's consider the first rule, public documents. What is the statutory definition of public document? Rule 1 states 1. Any rule of law under which criminal proceedings A. Published works dealing with matters of public nature. B. Public documents such as public registers and returns made under public authority with respect to matters of public interest. Paragraph C. Records such as the records of certain courts, treaties, crown grant, pardons, and commissions. D. Evidence relating to a person's age or place of birth. What public information and documents, what are the important elements of public information or documents? It must be A. Public works such as dictionaries, works, maps, and B. Public documents such as registers. For these documents to be admissible, certain conditions must be established. And let's ask ourselves, what are the conditions that must be established in public information or a document to be admitted? There are 4 conditions. First point, the record must be made by someone who holds a public office, such as a church minister, and that the document was created as part of that duty. There's an authority called Sterla and Frazier, 1800, 5, appeal cases 623. If I recall correctly, reading a note on this, that my understanding is other faiths were not recognized. And there's a presumption that the office holder would investigate the facts before the document is created, i.e., at least in a quasi-judicial position. However, it must be said that if it is challenged that public documents and information is challenged because of this authority, that would not be held correct in the modern society. This is because we have a diverse society now, and there are legislations competing. Therefore, that case is likely to be interpreted differently today. At any event, I'm sure the courts would admit the evidence under Section 117 or Section 114 of the Criminal Justice Act. In that sense, any difficulties Section 118 first rule has created is not something that we need worry about, because there are things in place that can easily overcome any difficulties. The second point is the information must be a public matter, such as a marriage. This does not mean that the public, as a public matter, the entire world or the country need to know. Even if a section of the community would suffice for this purpose. Third point is it must be a permanent in nature. This is again covered by an authority by the name of Hein and Fischel. The fourth point is the record must be intended to be public and able to be inspected by the public. The authority on that is Ianu and Dmitry. In fact, this case looked at the previous authorities that I mentioned. Looking at this matter, under paragraph C, records that are admissible as facts stated in them, such as court records, international treaties, it does not mention newspapers and journals. However, again, I would have thought the courts will give effect to such material. Paragraph D, evidence relating to age, date of birth, and place of birth. When one considers the age, the date of birth, and place of birth being added to this part of the section, is quite easy to understand. It has been added for practical reasons, because none of us can remember when we were born, where were we born, whenever we say where we were born and when we were born, our date of birth, what we are really doing is giving hearsay evidence, because we are repeating what our parents have told us and what we believe to be correct. In fact, very recently I was in court. My client was asked what is his date of birth. He said, I can't remember. The clerk of the court read his date of birth that was on the register and asked if that is his date of birth. And he said, I don't know. I can't remember. I literally sat in court, almost burst into laughing, thinking he is absolutely right. He's been asked a question that he possibly can't have expected to remember. However, we got over the problem eventually where he said, well, that is what I know it as. Next question that I posed at this juncture is, what is the overall effect of section 118, paragraph on public information and documents? There are several weaknesses and defects, some of which we just considered, and these difficulties no longer is a real problem, because section 116 could even come into play on matters such as date of birth. The parents might be dead. Or section 117 as a business document. Or section 114 being applied in the interest of justice. In my view, Section 118, Rule 1 is, in essence, is there for the purposes of completeness. The rule in Sorella and Frazier is, in effect, is now redundant. And that would be regarded as decided in per curiam, according to the modern interpretations, I would have thought. I would be very, very surprised if anybody were to interpret and say anything else. Therefore, considering the next point is what are records? Answer is such as court records and international treaties. Court records are obvious. They are public documents. Again, international treaties have always and traditionally been accepted as public documents. We covered the point with regard to date of birth and place of birth. The second rule that we will consider is reputation. What is the statutory definition of reputation as to character? Rule 2 reads, a person's reputation is admissible for the purposes of proving his good or bad character. Now, when you consider the authorities of bad character, you will note that there is a specific part in the Criminal Justice Act 2003 which talks about bad character. That could be how to deal with the defendant's bad character or that of a non-defendant's bad character. There are definitions and there are different gateways which we can look at as a separate subject at a later date. Here we are really looking at general reputation. Basically, or he's a nice guy, or he is absolutely awful, whatever. The third rule is reputation or family tradition. What is the statutory definition of reputation or family tradition? Rule 3 says, reputation or family tradition is admissible for the purposes of proving or disproving A, the pedigree or the existence of a marriage, B, the existence of any public or general right, or C, the identity of any person or thing. What is reputation or family tradition is, in fact, is to establish the blood relationships with people, such as this might be done through referring to headstones and the like if they had been in cohabitation, because they talk about the pedigree and family connections. These were the three parts that I intended to cover in this part of the program in this section. I'm not going to consider in the next part res gestae or confessions, because you would recall that in part 1 I said that I have decided to treat res gestae and confessions as separate topics, deserving as topics in their own right. Thank you for joining me in this part of the program, and I hope that you will join me for the third part in this part of the section before we move on to consider res gestae and confessions separately. Thank you for your valuable time. Hope to see you soon. God bless.